right, our second case today is case number 23-548, Security First Insurance Company doing business as Security First Florida versus Nancy Nicholas and Julie Mulder. Mr. Jacob. How much rebuttal time would you like, sir?
5 minutes, Your Honor.
You may proceed.
May it please the court. I'll get right to the heart of the matter. There is no textual basis in this policy for so-called separate and distinct tear-out coverage that appellee seeks. The only way to reach any tear-out costs is through the policy's if clause. Coverage there is for a single loss, not two types of losses. The if clause provides for, quote, loss due to the water, including the cost of tearing out. Including does not mean and. The plain meaning of including defines tear-out costs to be encompassed within one loss due to the water damage. In this including definition,
Counsel, you cited in your brief the opinion in Ray, the amendment 4. I believe you cited that for your proposition that including is a term of expansion, correct?
indeed.
Okay. And so help me with under that concept where you have including following the phrase loss caused by water as a term of expansion. For example, that the term direct physical loss may not include consequential losses such as tear out, wear and tear, things of that nature. But by using just the term loss, the policy language used the term including to expand to make sure that that is included.
Correct. So, Your Honor, in Amendment 4, at issue was the phrase all terms of sentence, including parole and probation. There was a dispute on whether parole and probation were indeed a sentence, but they were defined to be part of a sentence. But the court found that use of the word including meant that even if parole and probation are unlike a sentence in some ways, they are going to be interpreted to be included or encompassed within all terms of a sentence. So here, even if tear-out costs are intuitively something unlike damage, the policy defines the loss caused by water damage to include the tear-out costs, to include something that may be unlike what the damage is. And that definition of including was addressed in detail in the Supreme Court's 2017 decision in White versus spell it because I'll mispronounce it, M-E-D-E-R-I, McGeary, where the court identified that the word including is describing a part of a whole or encompassed within a whole. And that is exactly what's going on here. Also, the fourth DCA, fairly recently this summer, in two cases, one Pantieri and another case Harrington, identified that this same exact language, using the word including, brought the tear-out costs within that single loss, that loss caused by water damage.
Pantieri seemed a little bit closer to the policy that we have in this particular case, although not, and I'll ask Mr. Nation about it for sure, but not identical. It seems like the difference there was in Panettieri's LWD. It seemed to speak of the limitation of liability in the context of loss as opposed to damage.
That's right, Your Honor. So in terms of the including language, that was identical. But in terms of focus on the limitation and the LWD being a loss versus damage, there was a difference there. And certainly Panettieri addressed the Vasquez opinion, said Vasquez, similar to this case, you have Security First saying that that $10,000 limit encompasses water damage, including tear-out costs. Where in Panettieri, they were seeking and trying to refute any tear-out costs at all.
I can't speak for my colleagues, but for me, the challenge that I'm having with your client's position is the confluence or difference between loss and damage. And I wondered if you'd address that for me.
I will, Your Honor. So when we look at where coverage lies here, this is a wear and tear cost. So under the perils insured against provision, that is uninsured. There's no insurance for a wear and tear cost, except through the if clause. The if clause is an exception to the lack of insurance for wear and tear. So the trigger for the if clause is water damage not otherwise excluded. The exclusion section of the policy excludes the very type of water damage addition, right? So the if clause is ineffective, right? This is undisputed. The limited water damage restores that water damage, but it's the water damage that appellee has to use to trigger the if clause, right? So it's water damage that is being used for the if clause.
And this is like your Maspin's case, correct? This is the drainage pipe that we don't know if there's any damage in there, so
But here there is water damage.
I'll exclude them.
That's okay.
Yeah, here there is water, there is water damage.
Right.
It's triggering the if clause, and the limit of liability is for all damage provided by this endorsement. So this endorsement provides water damage that appellee relies on to access and activate the if clause.
What's all damage to covered property? That's what's limited by the limit of liability, correct?
Well, the limit of liability is all damage to covered property provided by this endorsement to $10,000 per loss.
Which is sudden and accidental direct physical loss. Tear out costs. That's never going to be direct physical loss, is it?
No, which is why I'll go back to the first point, which is the word including. So tear out costs would never be covered under this kind of policy. There's no coverage for tear out costs. Tear out costs are only accessible when they are treated as a subset. They are encompassed within the loss caused by the water damage. This is to the policyholder's benefit. It's allowing an extra cost to be covered that otherwise wouldn't be, but it's only covered within the single loss of water damage. That's the textual reading of the word including in the if clause. So,
But what is the water damage here? What covered property was damaged by the water?
there was water damage. So there was a discharge and overflow of water. There was water damage that was covered under the policy because of the limited water damage waiver. But in addition to that, there are alleged tear out costs. But
And wasn't it undisputed that the property that was going to be torn out was not actually damaged by the water?
that is true, Your Honor, and I don't disagree that intuitively tear out costs are not damage. The point is the policy defines them as such. And so the textual definition overcomes any assumed purpose for the tear out costs. But when the policy says that the loss caused by water damage, including
Stop there. It
Yes,
says
sir.
the loss caused by the water.
referring to the statement in the same sentence above, which is the water damage not otherwise excluded. So we're talking about the loss caused by the
So-
water.
I'm sorry, I'm sorry to interrupt, but so you're saying that we should insert the word damage after water and before including?
Only because it uses the word the. So when it uses the word the, it's talking about a specific type of water, which must be the water damage that is mentioned prior in the same sentence.
Counsel, you speak a lot about the textual analysis, and that's right, but I have a question about the declaration page. And then the structure of the policy. What clues do those provide us when interpreting this provision?
Your Honor, I mean, I think the declaration page does give an overview, a roadmap of the policy, but I think that when we're looking at the actual text of the provisions at issue, they are determinative, in the plain language of those provisions is determinative of the coverage available. So here, there is no coverage for wear and tear costs. Even the limited water damage endorsement doesn't restore a wear and tear cost coverage. The limited water damage waiver has to be used in the if clause to get to that kind of wear and tear cost loss. And when appellee uses the limited water damage endorsement to access the if clause, appellee is using it as water damage. And that's what the first sentence of the if clause says, is that it's water damage not otherwise excluded. So he has to be using the LWD as water damage. And when he does, then the limit of liability on all damage provided by that LWD is at $10,000 per loss. And that loss is clearly in the if clause, which is the loss caused by water, including tear costs. One single loss.
But can it be construed as one single loss? I mean, Black's law defines loss in a very broad way with, if it's unqualified, just loss. Then you have direct loss and indirect loss. And the Masscon's case actually refers to tear out costs as consequential loss. And so the lack of any qualifier in the phrase loss caused by water, including bringing in something that may otherwise, for clarity's sake, if for nothing else, bring something in to make clear that is part of the big broad term of loss, and going further to make sure that you maintain, your client maintain not covering the system for appliance. It goes on to say we do not cover loss to the system. And so you have this term loss with no qualifiers, not direct or indirect, physical, intangible.
Well, the one thing that we know from reading the policy is it is one loss in that if clause. It's a loss caused by the water damage. And what we know is that that loss has been caused by wear and tear, because otherwise that if clause would not be effective. It's effective only for the listing of certain causes like wear and tear or freezing of pipes.
Well, when you say it's caused by wear and tear, you mean indirectly? Does the wear and tear cause a failure of the system, which causes an expulsion of water, which then causes damage?
Correct. So the perils insured against section details a number of causes that are uninsured, wear and tear being one of them. So no insurance if there's a wear and tear cause, but it creates an exception in that if clause if there's water damage not otherwise excluded, which appellee has to take from the LWD and use as water damage to then satisfy that condition precedent for the if clause, to then reach the loss caused by that water damage, including tear out costs. And so that's a single loss. And again, it's to the policyholder's benefit that the contract is written that way, because otherwise the tear out costs wouldn't be covered at all. So they are encompassed within that loss by water.
Counsel, in order to reverse in this case, just want to make, I think I understand, I know your answer, but I don't want to make an assumption. We have to find not just that your construction is a reasonable construction and that your opponent's construction, we also have to find that your opponent's construction is unreasonable. Do we not? I mean, given the case law that says if there's two reasonable constructions, construed in favor of the insurer.
You do, Your Honor, and here there's only one plain language reading of this policy. I mean, there's no textual basis for two losses. There's no textual basis for two coverage. or for separate and distinct coverage. All of that is based on this assumed purpose of tariff laws. And respectfully, this is where the Vasquez opinion erred, is that the opinion assumes the purpose of tariff laws being unlike damage. And as a result, says, well, there must then be two losses, one damage, water damage, and one tariff. But that's not how the policy defines it. The policy defines it as including, as a part of, as within the loss caused by water damage, which is the same exact issue in the Amendment 4 case, where parole and probation were included within a sentence, even if they're unlike a sentence.
Let's save the rest of your time for rebuttal.
Thank you, Your Honor.
Sure.
Good morning, everyone. The coverage here.
That's not. Hold on.
We're gonna really speed up.
Yeah, you have to get to the good stuff right away. All right, you're at 433, Mr. Jaco, and I might have to just hold that because I have to reset everything. Go ahead, Mr. Nation.
The perils insured against says we cover, focus is there. We cover loss caused by the water. And it does say including the cost. So it's talking about two different things. It's talking about loss, which is diminution in value according to Mass Bonds or Black's Law Dictionary. We cover loss caused by the water, including the cost of tearing. So it's two different things, loss and cost. And they recognize that in their mold endorsement, as was recognized in Vasquez. In the mold endorsement itself, it says this limit applies to subsection 1 of the mold endorsement, the loss caused by the mold. And then in subsection 3, and it has including the cost of tear out. The cost of tear out is specific, important, and it can't be limited in a way that is unreasonable. And here it is quite unreasonable. The deck sheet itself in 3 different places says water damage limitation. They charge an extra premium for it. Water damage surcharge, limited water damage coverage. And you get to the endorsement itself, and the endorsement itself is named water damage, limited water damage endorsement. You look at the water damage exclusion, doesn't mention tear out anywhere in there, mentions water damage. And then we get into the grant of coverage that's in the limited water damage endorsement, sudden and accidental direct physical loss caused by water from a plumbing system. The limitation then, which has to be interpreted narrowly, we get to the next section. The limitation says this limit applies to all loss caused by, or all damage, well, all water damage. Water damage, very specific.
If it's loss, it's very different.
Yeah,
right?
it said all water damage or all damage to the covered property.
In loss, and why don't you address Panettiere for us?
Yes, sir, easily.
Because I think that's probably a decent segue.
So, and can I say one thing about Vasquez first? And so in Vasquez, you'll recognize they're making a different argument in Vasquez. The same insurance company, the same policy language. They made a different argument in Vasquez than what they're making here to try to get around Vasquez. If that isn't the height of an ambiguous policy, what is? Now, Panettiere came out. Panettiere comes out, and what Panettiere says is, and I can break it down very easily, Panettiere and Vasquez both deal with 3 policy sections. Same 3 we're dealing with here today. Perils insured against, water damage exclusion, limited water damage endorsement. But they reach the opposite results. How? Under the perils insured against, they're basically identical. You get coverage for the loss caused by the water, you get coverage for tear out. If it ended there, you'd have full coverage A limits for both water damage and tear out. Then you get to the water damage exclusion. If it's excluded, you get 0 for water damage, 0 for tear out. Then you get to the limited water damage endorsement, and it is diametrically opposed to the way they're interpreting their own policy here today in the way they did in Vasquez, and it's this. In Vasquez and here, it's their position that the limitation of $10,000 applies to the water damage and tear. And so Judge Evander, in oral argument in Vasquez, asked this question of security first. If there's $2,000 worth of water damage and $8,000 worth of tear out, under your interpretation, security first, you get $10,000 under your limitation. Answer, yes. In Panettiere, the position taken by that court, People's Trust in that case, was you get 0 for tear. You only get 10,000 for water damage. Diametrically opposed analyses. That's not how security first interprets this file. Panettiere simply says you get nothing for tear out. How they did it? Well, I got hired after the summary judgment was lost to do that one. We got that up on appeal, and several other DCAs fully briefed that specific issue about how do you interpret it. But Panettiere has absolutely no applicability here today. In fact, on page 10 of their reply brief, it says we are not relying on Panettiere because the language in this box is the same as the language in Vasquez. Kind of a long answer, but
Wasn't what I thought you were going to say. I thought that you were going to hew more to the plain text of the limit of liability clause in Panettiere.
it is. It says all covered property as opposed to all damage. And so the other argument is it just doesn't apply at all because it says the limit applies to all, I think, all covered property in Panettiere as opposed to all damage in this case. And so it's a different limited water damage endorsement. And so differently worded, I guess I got off on sort of a pet peeve on the.
Yeah, you were
difference
talking more about what counsel was arguing, and I'm not really sure in Panettiere, I'm not really sure that that's going to drive our decision as much as the text of policy.
Yeah, I understand. But in Vasquez, the way they interpreted Vasquez is different than Panettiere in that they agree that the limited water damage endorsement provides coverage for both water damage and tear out. The question is,
In the Panettiere court itself says that they're distinguishing the case before them from Vasquez, do they not?
they do say that. They do say that. And in this case, and let's see. I just wanted.
Well, what about appellant counsel's argument, though, that when you, and Judge Traver just touched on this, looking at the language of the policy. So you have the section 1. Then in this case, there was the water damage exclusion, which was referred to as the WD Act,
Yes.
which excludes this discharge or overflow of water from plumbing, et cetera, system. Then there's another endorsement, the LWD, which now puts back in coverage for discharge from plumbing, et cetera,
Yes.
but then has this limit of liability. And so what's your response to the argument that to the extent your clients have coverage for tear out costs, it only goes back to the if clause, and under that, your clients are limited to loss caused by the water damage that your clients bought back for a premium or the LWD, and that the limit of liability for water damage, which the argument is, includes tear out costs. That the language answers the question.
Yes.
And 10,000 limits everything: damage to cover property, direct damage, consequential damage for tear out costs, any kind of damage, if it's caused by this water flowing from out from the system, $10,000, that's the limit.
And it is damage, and tear out is not damage, and they have not defined it that way. They've simply said, we cover loss caused by the water, and then they're granting coverage, including they put in the cost of tear out. That is not a definition of water damage. That's a definition of their coverage. They cover loss caused by the water, and they cover the cost of tear out. And they know how to exclude or limit damage or tear out costs because they do it in their mold endorsement. But also, if the court were to say, and you touched on this, right? And that is, if you were to say their argument is a reasonable, they have to prove that ours is unreasonable. But if they have a reasonable argument, you can then look at other things in the record, such as their new limited water damage endorsement, which specifically says the limit of liability, which has to be interpreted narrowly. The limit of liability applies to the damage and it applies to the cost of tear out. And I put that in the record, and I also put other limitations from other carriers that you're allowed to look at if their interpretation was reasonable. I don't believe
But
it is.
appellant's counsel's argument on that mold issue is, well, the language is different. Here, it's argued by the appellant, if I'm understanding this correctly, that your client's ability to recover tear out costs comes only from the if clause under the perils insured again. And so therefore, there is no reason to have this express language present in the mold endorsement, because using this term including in loss caused by water damage, that is clear and express language. That's my understanding of the argument, if I'm understanding.
I believe you are. I believe you are understanding their argument. But it is important, if we're talking about a limitation here, it is important to be able to say specifically what is limited. Here, the water damage, loss caused by water is a specific thing. It is a loss, diminution in value. The coverage then goes on, and it is we cover the cost of tear out. It's not limiting this definition of water, it's granting coverage for tear out. Tear out is nothing like the water. It is a unique coverage giving you access to the thing that caused the damage. And if they make a specific grant of it here, if they're going to limit it, they need to limit it specifically also. And they can't, in vague and ambiguous terms, say, well, we've defined it here, and therefore a limit applies, when the limit specifically says it only applies to all damage. If they mean to limit the tear out, they should say all damage, including tear out. But they were very specific that it only limited the water damage and not the access to the pipes. Obviously, I put in 70 trial court orders that rule this way. And the reason I did that is to show, at a minimum, we have a reasonable interpretation of the clause. If the court were to find theirs was too, then it has to be interpreted in favor of the insured. Yeah, I don't think I have anything else, but any questions at all?
Thank you.
All right. Thank you very much.
Your Honor, when Apley reads this language, he leaves out words. It says the loss caused by the water, including tear out costs. He leaves out the word including. There's no two bases of coverage. Even in oral argument in the Vasquez case, he argued that you should read it, we cover including tear out costs. But including isn't an adverb, it doesn't modify cover. It modifies the loss caused by damage. It's the only way to read it. There's Supreme Court precedent on this very issue. I mean, that's a definitive reading. It's a plain language reading that including encompasses the tear out into the loss caused by water damage. He raises the mold endorsement. That's a totally different endorsement. That mold endorsement can be effective without water damage. So the mold endorsement doesn't use the if clause where the tear out costs are, because the mold endorsement can have tear out costs without water damage. But by necessity, the limited water damage endorsement's always going to have water damage, right? So it's using the if clause to reach the tear out costs. Those are apples and oranges. So again, the mold endorsement needs to have tear out costs mentioned in the endorsement because water damage isn't a prerequisite to getting the tear out costs in with that particular type of loss.
What, if anything, is the relevance of your client making some subsequent amendments to its policies to further elucidate this?
One, Your Honor, the case law is clear that, you know, a subsequent revision doesn't mean that the original language was ambiguous. And just because they put that in there to avoid active litigation, shouldn't be used against them. Also, you mentioned 70 orders. Of those, there are only 6 deal with the language at issue here, and that's in our briefing. And
I think the underlying argument from that, though, and I recognize that it could be 150 million orders, and they're not binding. You know, maybe they're persuasive on us. I think the argument might be from your colleague that those 6 outlining the language in the exact way that he's proposing that we outline it is somehow evidence that his interpretation is reasonable. So that's the reaction. I don't think it's the volume. The number doesn't matter to us because it's not binding, but I think the argument goes to its arguable reasonability.
what I would say to that, and I would also respectfully say to the Vasquez opinion, is that when those orders are based on a presumption that intuitively tear costs is not damage, as opposed to being based on a textual reading that tear costs are included within the loss caused by water damage, that's an unreasonable reading. To interpret language based on its purpose is unreasonable. And again, that's what the Amendment 4 case, supremacy of the text, addresses. And the Supreme Court standard is you do not start with the purpose of the language, you start with the text of the language to gather its interpretation. And finally, I'd say, I think Pelley made our point. He said that the limited water damage supplies water damage to the if clause. So the liability limit on that water damage should also apply. When the LWD's water damage is used in the if clause, it brings with it or carries with it that $10,000 per loss limit on that same water damage, which includes within it the tear-out costs. That's a plain reading of the provision.
Thank you very much.
Thank you.
You guys are both here for the last one, so you'll think I say this to all the appellants and appellees, but this was very well briefed and well argued. We've given us a lot to think about. Thank you for the presentation. We'll be adjourned.